no correspondence needed, which is the vast majority of the online recordations. We're talking about less than a week.
Great. Well, that's great news. In September, several House Judiciary members wrote you regarding concerns with what they described as the proliferation of performance rights organizations. What's your response?
I understand the issue. Performance rights organizations play a very valuable role in helping to make licensing easier for everyone. But where there is a proliferation, and there are more and more, it's critically important for users to know what repertoire is represented by whom, so they can make their decisions.
Yeah, it seems like some of the more well-established ones I'm not concerned with, but there's a multiplication here that's concerning me, and be interested in maybe getting a report back from you all on the current state of play.
We are planning to follow up by issuing a notice of inquiry and looking into what the experience has been.
Last one, and then you're currently in the midst of a 5-year review of the Mechanical Licensing Collective, MLC, created by the Music Modernization Act. What insight can you give us into this process?
We are currently reviewing the input that we've received. We have asked for both public input and also for the existing entities to give us a report on how they're doing and what they've been doing.
Can you comment on any concerns about transparency at the MLC?
No, we are listening to input about what all of the concerns are and taking it seriously.
Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Hirono is going to defer to Senator Welch. Senator Welch.
Thank you very much. Thank you, Chairman and Ranking Member. I want to follow up a bit on the questions that the Chairman was asking about creative material. It's really tough for many artists, and if their material is used to train AI, my view is that they should be notified of that. My view is that they should be compensated for that. But there's no way in which they can actually get the information. And I'm considering legislation that would make it more possible for them to do that. But first of all, in terms of your experience and your position, are you getting expressions of concern from the creative community about the use of their work to train AI and their inability to have any way of determining whether, in fact, that's the case?
Yes, absolutely. I mean, certainly concerns about the use of their work to train AI, and that's where we will be talking about the fair use analysis in our upcoming report, but also the transparency issue, because the copyright community the copyright owners are expressing concern that unless they know if their work was used to train, they can't do anything about it, whether it's to license or to bring a lawsuit.
And that's true.
That's true. So, and this is an area, of course, that touches other interests besides copyright as well. There's a lot of reasons why transparency is important in AI training.
And what's the pushback on that?
My understanding of the pushback is that it's really more about what kind of transparency, how much, and to what degree of detail, and how would it be provided. And I know that discussion has been going on now for some time in the EU as well.
This is pretty simple. Your work, your creative work, it's used in training or it's not, right? So how much more transparency do you need than the company training its AI model to ask them the question, did you use my song?
Yeah, my understanding is that one of the issues is the extent to which it's possible to reproduce, to identify exactly which works were used in which training model.
So, there's something really wonderful about this. AI, knows everything, right? Except that which the artist needs to know to determine whether their work has been used to benefit AI. So can we take seriously this assertion by the AI folks that know everything, that they don't know what work they've used in order to train their wonderful AI model?
Well, I do think it's important to have that level of transparency to allow copyright owners to make decisions about what they want to do.
But we're in a new world here in a sense, because it was never contemplated with the fair use doctrine that there was such a thing as AI that would utilize and vacuum up not only information but creative content from artists who are always getting squeezed with the use of their models. So it sounds like we do need some explicit protection for artists if their work is used to train AI models.
Well, I would differentiate between the use of the works in the training and transparency about what works are used. So I think the fair use doctrine is flexible enough to deal with the training, but transparency is an additional issue.
In order to have the fair use doctrine interpreted and applied to a concrete situation, then there has to be transparency so that the court or the decision maker knows the initial question, this creative content has been utilized for the benefit of the AI algorithm.
Yeah, I mean, not just the fair use doctrine, but the entire infringement analysis could only take place if you know what works are used.
All right. Thank you very much. I yield back. Thank you, Mr. Chairman.
Thank you, Senator. Senator Blackburn.
Thank you, Mr. Chairman. And Ms. Perlmutter, I enjoyed our conversation yesterday, and thank you for taking the time to come by. And as my colleagues have said, the work you do is important to my fellow Tennesseans that are songwriters and artists and authors and musicians. Your office is vitally important. I will say also to a lot of our healthcare innovators that have patents, it is vitally important, and it's why we are seeking to work on this issue and protect the constitutional right that our innovators have to benefit from their creations. I remind them all the time, Article 1, Section 8, Clause 8 is about them, and we should be protecting that. I want to stay with the fair use question for just a minute, and I appreciated your report. We touched on this yesterday, and I appreciated the opportunity to submit my comments on the topic during your notice of inquiry last year. And I've said before, and this is something we say a good bit in Nashville, fair use is a fairly useful way to steal my creation. And we've seen this happen a lot in the music industry first and subsequently into others. And I addressed and argued for a narrowed application of that standard in the Warhol versus Goldsmith case, which, as you know, sided with the original photographer in that case. And I think that having that clear understanding is vital. So coming a different way from my colleague's question, when we talk about this, and you talk about this unlicensed AI ingestion of copyrighted works, then should that or should that not be considered under a fair use doctrine?
Well, the fair use doctrine applies as long as you have an initial act of reproduction. And one of the beauties of the fair use doctrine is, even though, of course, it was developed at a time before the existence of AI, or certainly generative AI, it is flexible enough to apply to new technologies. So the doctrine applies. How you apply it, though, is a different question.
You would apply it in that, and I think that's an important distinction.
Yes.
That yes, indeed, it does apply because of that flexibility. And therefore, that gives standing to these original creators to go after bad actors. And of course, with the No Fakes Act that Senator Coons and Senator Tillis and Senator Klobuchar and I have, this is something that would provide that extra protection for these creators. So whether it's copying their voice or copying their works, they have a legal standing and a right to defend themselves in their creation.
Yeah, which is important because copyright law doesn't extend to protecting images and voices in themselves. So I agree that's important. And also, just to clarify, when I say fair use applies, I mean the doctrine is available to analyze that situation, not that we've concluded that something, any
Right,
particular conduct
exactly.
is fair use.
As you said, it has flexibility.
Yes.
Okay, I want to ask you about something else that has come up recently with some of our artists, and this is Spotify's bundling system. And as you can imagine, we've got a lot of people whose music is on Spotify, and they're not really happy with this. And they feel like what Spotify did with offering audiobooks. And then, you know, they're doing this, these standalone subscriptions, and then they reclassify 50 million users. And in the end, the creator gets less money. So I'd like to have you comment on what protections are there, because every time somebody does this, every time Spotify does this, when you look at them coming up with these bundle plans and offering the audiobooks as a free service, if you've got the monthly music subscription, and then turning around and doing a book subscription standalone a little bit later, and then reclassifying their 50 million users, it is Spotify that's making the money, and it is the creator that gets fewer pennies.
We're certainly aware of the
Okay.
issue and of the litigation. I can't comment on the merits of the pending litigation, but we are following it. It is the issue of how you calculate the royalties for bundles is not something that the Copyright Office is directly involved in. It really is a question of the regulations of the Copyright Royalty Board. But we are certainly following
watching.
what's happening in the
I
litigation.
appreciate that. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Senator Hirono.
Thank you, Mr. Chairman. It's very clear that when we deal with AI and the impact that it has on just about everything in every sphere, it's really difficult to figure out what kind of regulations there should be. But it does occur to me that there are other countries that are having the same issues. And one of the questions I'd like to ask you after I make some initial comments is, how are these other countries dealing with this issue? But thank you for joining us. I know that you are tackling this really important issue, and I just read a New York Times article. It was in January. The sleepy Copyright Office in the middle of a high-stakes clash over AI. It was quite an informative article, mainly, talking to you. But I know that you and your team are working on reports on the relationship between artificial intelligence and copyright, and this is a topic, as I mentioned, of great interest and concern to me and this committee. AI is a powerful tool that should be used to enhance and support creativity, but we have to make sure that we don't sacrifice our artists, authors, actors, musicians, singers, songwriters, journalists, and other creative professionals. Our copyright system exists to incentivize and compensate these creative professionals. And the framers of our Constitution cared so much about supporting the creativity of all of these individuals that they actually put protecting copyright in our Constitution in the intellectual property clause. So what you're doing is really important. So getting back to how are other countries dealing with the AI issue and the creative community in their countries?
I would say that other countries are like us, examining the issue, trying to figure out the right way forward. There are a few countries that have enacted very specific exceptions in their copyright laws for text and data mining, which they either have said they will apply, or there is speculation that will be applied to generative AI training. But these exceptions have not yet been tested in court, and we don't know how the courts will apply them and the extent to which the results will be different from our fair use doctrine. I will say there's a lot of conversations going on internationally. We're talking to our counterparts. Everyone is sharing information. The World Intellectual Property Organization is holding regular, what they call online conversations about the new technology issues, and they're all focused on generative AI right now.
Considering that other countries don't have to deal with, I don't think, the issue of First Amendment freedom of speech considerations, is that another a factor for us to consider when we're talking about regulating and making certain requirements
It
of
could-
disclosure and compensation?
It could be. Other countries are concerned about free expression and do have some protections for it, but they don't have the equivalent of our First Amendment.
So where are you in working on this report? When will the report be due? And I understand that you have gotten thousands and thousands of comments from
10,000.
people.
10,000, and I will
10,000.
say, it's not the maximum we've ever received. We got more for our study on Section 512 of the DMCA a few years ago, but a lot of those were duplicates. These were 10,000 substantive individual comments, so it's taken a lot of analysis and a lot of review. So as you know, the first part of the report was issued the end of July. We have been trying to set and follow our own ambitious deadlines because we know there's a lot of interest. We know these are important issues. So our current goal is to get the other two sections out by the end of the year. We are working hard toward that goal, but to me, what is most important is to make sure that we are accurate and thoughtful and produce a high-quality report that will be useful to you and to the courts.
Well, my best, because whatever you all come up with, I think we're going to see litigation in this space. So we shall proceed. Thank you very much, Mr. Chairman.
Thank you very much, Senator Hirono. Let me just begin a second round by briefly asking about the Copyright Claims Board. I was actively involved in the legislation that created it. I'd just be interested briefly in hearing about your efforts to introduce the public to it, to publicize it, to get more participation. And in reviewing some of the basic data about it, it seems there's only been about 24 final determinations out of 1,000 claims filed. Could you help me understand why?
It's interesting, and you, of course, know the statute even better than I do. I think the process was set up to make sure that inappropriate claims didn't get through and that this didn't become an environment where there were frivolous claims, claims that weren't really copyright claims, and so that's what we are seeing. So a large number of the claims that come in, I believe close to half, and I'd have to check the numbers, don't make it through compliance review. And often it's because they're really patent claims or they're claims brought against someone in another country, which the CCB doesn't have jurisdiction over. And then there are people who, there are various reasons why the claims don't meet the requirements of the statute. And often people have trouble completing service of process because the service rules can be complicated.
Well, I look forward to staying in touch about what, if anything, we can do to help improve it and help it achieve its goals. I really want to focus on piracy, if I can.
That's fine.
Copyrighted content is being pirated now that streaming services are very widespread. Piracy has taken a whole nother leap. By some estimates, it's costing the creative community here in the United States and industries that are built on creative works $30 billion a year and thousands of American jobs. Some of our peer countries, developed democracies, are now using no-fault injunctions as a way to prevent this. I'd be interested in your sense of the contours of who's doing a good job at it, what are the components, as we're considering possible legislation, what we should be looking at. The other thing I'm interested in hearing about is safeguards. What sorts of safeguards other countries have put in to ensure that protected material isn't improperly removed? Look forward to your comments.
We now have seen, as of about a year ago, there were at least 33 countries that had implemented the no-fault injunction possibility. And what we're seeing is that what they have done is more and more put safeguards in various forms. One type of safeguard is to make sure that your targeting those websites that reach a pretty high threshold of being dangerous. So websites that are dedicated to infringement. We're not talking about a website that might just happen to have some infringing content on it. So that threshold is very important. And then different countries have different standards in place that generally talk about proportionality and balance, taking into account the interest in access to information, for example. So the injunctive relief should be narrowly focused and targeted and directed in an appropriate way so that it doesn't overreach and it doesn't cover too much content. I would be happy to provide, the details of some of these laws after the hearing, but what we are seeing is that where you've got these laws that are provided with appropriate safeguards and balance, that more and more studies are showing that this is effective in reducing piracy at least when you apply it to more than one website, when there's a number of sites in the given jurisdiction.
My sense is some of the injunctions issued in other countries are dynamic, meaning they're going after essentially a business model that says, here's 50 Disney movies that you can access on this site for free. And when there's an injunction placed against that specific URL, they just shift to another, shift to another, shift to another. And they've tried to structure injunctions that can track that shifting. Is that accurate?
Yes, that's my understanding as well.
I'm very interested in our moving forward in this area because I think this is putting us at a competitive disadvantage that we aren't utilizing this. And I look forward to working with you on getting input on what would work and what would work best in this field. Let me defer to my colleague and friend, Senator Tillis.
Ms. Perlmutter, we're hearing some concerns about protecting live events such as sporting events and privacy. Would an expedited removal scheme under DMCA be a possible solution?
An expedited removal
Scheme under DMCA.
More expedited than it currently has?
Right.
For live events specifically. That's an interesting concept, and I would be very interested in hearing more about it.
I was curious. I was raised by my staff. I had some feedback after you all did the new rule, I think, for group registration for updates to news websites. Got some concerns that maybe I think businesses or publications like Barron's, MarketWatch, Page Six, and others have been denied by the office. Can you tell me whether or not we should have a more expansive definition of what a news site is? So are your thoughts on those denials, whether or not they're appropriate or we have to come up with a more expansive definition?
Yeah, well, I would start by saying I'm very proud of the work we did to get that rule out, the new group registration option. We completed it in record time for any new group registration. It was just over 6 months from the first notice to actually having it be implemented and enforced and usable. It's been in operation for just 3 months. We've had, I think, close to 100 applications at this point. It's all very new, so we are looking at how the existing definitions apply to what types of works. In order to get the rule in place very quickly, we used an existing definition so that we didn't have to go back and reinvent the wheel. And so the question will be now, is it working? And we're committed to continuing to have conversations with the stakeholders about it.
Okay, I'm going to submit, I do have another question I want to ask you, but I'm going to submit a question that I feel like is a little bit in the weeds that has to do with something as simple as photographers. They'll take 2,000 photos in an average wedding shoot, for example. But there are limits right now. I want to just submit the question. I think they were using as an example. They take an average of about 2,000. I think there's a 750 image limitation now. It requires a lot of triaging and work. What do you say to them?
We are planning to increase the limit, and in our new ECS system.
What sort of time frame?
We are going to be, the limited pilot that we'll be releasing by the end of the year, so that's in about 6 weeks, will have within it this e-deposit upload system that people will be able to try, and once that's in force, in effect, and implemented, it will allow 2,000 photographs to be uploaded simultaneously, and we will be able to accommodate that number in the new registration system in a group registration. So the pilot will be by the end of this year, and then we will be working on integrating the pilot with the rest of the system next year and probably the year after, and as soon as we can, we will be making sure that the larger number will be able to be accommodated.
Good. For the purpose, or for my, I'm going to submit some questions for the record, but I always try to give witnesses this opportunity. What's the one question that you wish we asked so that you could give an answer to it? What is it in this oversight hearing that we need to know about that we haven't discussed already?
Public performance right and sound recordings. The Copyright Office has supported adding a public performance right for sound recordings to U.S. law for decades now. The administration, over multiple administrations, has supported it. There have been bills introduced in Congress, and the United States is one of the very few countries in the world that doesn't have that right. And because most countries recognize foreigners getting the royalties on a reciprocity basis, we are leaving millions and millions of dollars on the table abroad. So that is an area that we would love to see action, where we would love to see action.
That's a real good point. I'm glad you brought it up. What about resources? How are you doing in terms of resources? You've done some modernization with the ECS and other things. Where do you need help in just making sure the plumbing is modernized and as efficient as it can be?
Well, we've
I'm
really,
not doing it for your sake. I'm doing it for the sake of the users. You just benefit from it.
well, we're doing everything for the sake of the users as well.
Exactly.
We really appreciated the funding we got from Congress, 5-year funding for modernization in 2019. We have been able to make a lot of progress, but we are now looking to expedite and accelerate our work on the registration component of ECS, and in order to do that, we will be asking for additional funds in the 26 budget.
Good. One thing to be helpful as an old project manager is I'd like to take a look at, we're 5 years down the road. You've had funding. I think you've been a good steward of the money, but I'd like to have an after action on these projects, where they were in terms of time, budget, estimated, complete. That'd be helpful. If you could submit to the record, I would appreciate it.
Absolutely.
Thank you, Mr. Chair.
Thank you, Senator Tillis. Register Perlmutter, thank you for your participation in this hearing and for working with us to ensure that the services you provide are more accessible, more modernized, and we're grateful for your policy input. This, according to my book, is our 9th consensus hearing of this Congress, and I appreciate your partnership. Senator Tillis, we will continue to probe some of the challenging, emerging, and thorny issues at the intersection of AI and copyright and how to combat digital piracy, and we welcome your partnership in those efforts. Members can submit questions for the record for the witness until 5 p.m. 1 week from today on November 20th, and with that, this hearing is adjourned.